hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone, and welcome to the Appeals Court. We are your panel for the 6 cases today. My name is Amy Blake. To my right is Justice Suk-Young Shin. To my left is Justice Catherine Hand. Most of you have been here before, but just briefly to go over the rules, each side is permitted 15 minutes of argument. There is no rebuttal. I assure you that we have read everything, so you should get right to your arguments. With that, I will call the first case today, Commonwealth versus JHONATA Souza. I'm sorry if I've mispronounced that. Docket number 23P1438. Mr. Benyon, good morning.
Good morning. May it please the court and to the Chief Justice. I'll start my argument by quoting a justice who I greatly admire. This is Justice Cardozo, sitting on the Supreme Court, speaking for the full bench. He said, "We have not traveled in our search for the meaning of the lawmakers beyond the borders of the statute." I imagine this argument is going to go with, obviously, the district attorney's office, but I imagine you too will run outside of the statute to make this make sense, and it is my job to bring you back. I'll start by reminding you that you cannot just give any word, any interpretation that you wish. Under statute, if you go to Chapter 4, Section 6, in construing statutes, the following rules shall be observed. And in the third, it says, words and phrases shall be construed according to the common and approved usage of the language. Here we have 2 statutes, one with force, one without force. Here we have a person who was convicted of rape with force, where there was no force, no actual force, no threat, no intimidation. That is an element of the crime. It was not proven. I am asking you to please apply the statute as written for the lesser included. That's what the defendant argued in the lower court when he asked in both his motion and in the required finding. And that is the right way for this case to come out. Now, shall we talk about constructive threats or constructive violence or constructive force? I really like the way the court phrases this, and I'm going to ask you to go to my brief. On 40 and 41, you have a jury charge. It's old, it's from 1949, but this gives a good explanation as to what constructive force is. If you look it up in Black's Law Dictionary, it just gives you the definition of a threat. It's just a threat. And the statute uses the word threat. The reason why you have 2 statutes is if there is a rape and if the victim decides to protest and if the defendant then through force or threat of force overcomes the will of the victim, then that statute can be used. But if there is no protest, then you would look to the statutory rape without force. What has been done, if you look at the instruction from the SJC from 1949, you can see a change in the way constructive force has been interpreted, and that's a problem for my client because it's become an objective standard to one that is subjective to where the jury is just basically invited to look at the circumstances and the climb inside the mind of the victim, and if she felt overborne, then the jury can find that there was constructive force.
But isn't the jury still required to find that it is the defendant's conduct that causes that response in the victim?
Yes, and that's what brings me to this wonderful hypothetical that...
Why is it so different? This is the problem. I understand, surprise you, I guess. Why is this, other than literally there being a number of people involved in the bank scenario, and not so in the case of more like what we're looking at in this case, why is the action of a defendant in the past that creates an atmosphere of fear not the equivalent of having another group of people that create an atmosphere of fear? I'm missing that.
An excellent question, Justice Hand. Here's the answer. In the scenario in the bank, and we can come up with other scenarios, but the bank one is nice because you have multiple people that come in, guns are brandished, one person without a gun goes up to the cashier window and either takes the money or in this, you have an objectively reasonable standard whereby a jury can look at the facts and say, I think it's pretty clear that this is a threat. Now, whether it's one person or multiple people, what we're looking at here is we want to keep that objective standard. Here, all you have is the government asking the victim, were you scared? Why? Oh, he exercised this, I can't remember how it's phrased, but he scared me. He would yell or, but there was never a threat with respect to the rape. In other words, a jury can't climb inside the head of the victim every time just to see, in the context of the victim, whether she felt intimidated or not. There has to be something that goes to overbearing her will to the rape.
Do we assess the reasonableness of the outside influences that created that sense for the victim?
So the statute says that it has to be pertaining to the event. And I'll just read the statute really quick because I want to keep you on point. Because I think it's written in a way and compels such child to submit by force. Now, I understand that, and I'm not saying that it has to always follow attempted rape, threat of force or force, and then acquiescence. I get the fact that a defendant can set a scenario up, kind of like the bank, where the will is overborne at the event of the rape. I'm not saying that it has to be that sequence of events, but the threat has to go to overbearing the victim's will with respect to the rape. There has to be some objective conduct that shows, in other words, just being aggressive sometimes doesn't get you there. You still have a statute that covers what the defendant did. That's why I'm having such trouble with this, is because there's a statute that covers it. And why we're going to this forced interpretation of the word forced, I do not know. Only then you've allowed the government to do this so often that that's just what they do.
Can I ask you a different question, which is as to the standard of review?
Yes.
You claim in your brief that there was a motion for required finding. I don't see it in the transcript. So are we reviewing for substantial risk?
No, there was sometimes.
For the statutory rape charges, yes, but for the rape of the child with force? In fact, I believe the transcript says something like, from defense counsel, there's enough for that, I'm not moving on those.
Well, with respect to rape by force, the government still has to prove the element.
I'm just trying to understand what our standard of review is, because I don't see a motion for required finding for the charges that you're contesting, rape of a child with force. Counsel acknowledged that there was sufficient evidence on those two and argued it on stat rape only. Two different indictments.
Yeah, that is true. This is a statutory construction argument.
I understand the argument is still, I'm just asking you what our standard of review is.
If there is no required finding, then it is a substantial risk of miscarriage of justice. However, case law bears out that not proving an element of the crime soars over that standard.
So if we, in order to accept your argument, it's a two-part question. In order to accept your argument, do we, A, have to overrule any of our prior cases, and
I'm sorry,
B,
could you repeat that first part again?
in order to accept your argument about the statutory construction, would we, A, have to overrule any of our prior cases, and B, would we be holding contrary to a decision of the SJC?
Yes, you would.
To both questions?
Yes.
So how do we issue a ruling that's contrary to a decision of the SJC?
Because you, as a court, cannot change the language of a statute to broaden it. That case law is clear. You cannot change the definition to incorporate more of a criminal behavior than what the legislature has allowed.
But if the SJC has already interpreted the statute that way, how can we decide differently?
Are you just setting this up for FAR?
Well, yes, but no. So I'll be a lawyer. There are two ways to look at this. The first way to look at this is to say that there are statutes that clearly say that you have to interpret a statute as written. You cannot go outside the definitions, and clearly that is what precedence has done. So on the one hand, you can say, we're going to take the lesser of two evils. I don't believe you have ever sworn an oath to uphold the SJC's precedents, but I do believe you have sworn an oath to uphold statutory positive law, which is what I'm asking you to do. Now, if you're too timid to do that, that's fine. May I suggest an alternative course, and that is write an opinion that says we are going to affirm. We understand there is case law that has interpreted this, but we find that case law unconvincing and poor, and we'd ask the SJC to take another look at this because it's just wrong. It's not fair what happened in this case. There's a law that covers what my client did. That's what he should be convicted of. It is, and this happens more often than you think. This is not the first time I've argued this as the district attorney's office has brought this up. I'm glad they brought up that case. I would invite you to please listen to the oral argument. It was kind of fun. The court picked up on the issue. You'd have thought I was going to win that easily, but it was an unpublished decision.
That panel timid?
I like to think the best of judges, so I'm going to say they just thought that they were going to stick with precedents.
I'm just curious because it's an all-female panel today that your choice of the word timid was kind of jarring to me.
Oh, I apologize. It wasn't meant to be anything other than a hope that you would embrace the idea that a judge's role is to interpret statute, the words being what a reasonable person would understand them to mean.
I appreciate your argument that if you want us to say, hey, we're constrained, but we think it's wrong, that's a very reasonable argument. It's an argument we hear, not a lot, but from time to time. But to suggest that we're not going to follow SJC precedent because we're timid, that one missed the mark for me.
I guess it depends on how you, or what excites you about the law. When I read cases about, when I read Article 30 of the Declaration of Rights that says that a judge cannot exercise the judicial power, when I read cases about how a court is to interpret statutes, how they're to stay within the what the lawmaker designed to do, that excites me because it sets the law up as understandable, as predictable, and to just affirm a case like this just because of precedents bothers me. I am just trying to get it to bother you.
In the previous case you mentioned, did you seek FAR?
I did.
And was it allowed or denied?
It was not allowed.
Okay.
But that doesn't mean we don't try. I will remind you that in 45 years ago, the U.S. Supreme Court decided a case called U.S. versus Roberts, where they essentially gutted the Confrontation Clause. And defense attorneys for 30 years argued that issue and lost until 2003, when Crawford versus Washington came down. It is important for attorneys to make these arguments. Even if you're going to affirm this conviction, it would be wrong for you to do so. And I think history will show that, and I think that this interpretation cannot stand. No further questions? I will sit down.
I don't see any. Thank you very much. Attorney Monahan.
Good morning. May it please the court, Assistant District Attorney Megan Monahan on behalf of the Commonwealth. The defendant's convictions for forcible rape of a child should be affirmed where, when we consider the totality of the circumstances presented to the jury, including the historical and contextual relationship between the victim and the defendant, as well as the manner and means by which this rape was perpetrated, the evidence overwhelmingly proved beyond a reasonable doubt that defendant effectuated the rapes by force under a theory of constructive force. I can, Your Honors, go through the evidence in detail, but I understand you've read the briefings. Unless there are any questions about the sufficiency of the evidence, I can take some time to address constructive force and the statutory interpretations. All right, thank you. As Your Honors have alluded to and how counsel has addressed, this precedent has been a long-standing precedent. Constructive force was first addressed in Commonwealth v. Caracciola by the Supreme Judicial Court in 1991. Reading the statute, specifically that was for rape, not for rape of a child, but for rape, the court found that reading the plain language of the statute and the legislature's historical use of the phrase force, that physical force and constructive force was encompassed in that statute. That was a correct interpretation, Your Honors. I would suggest that's based in the historical use of force in robbery cases, and it's noted in Commonwealth v. Caracciola. The SJC said, why would we grant greater protections to a crime of property than we would against a crime of person? And that is the reasoning behind force and constructive force. And I would suggest that the legislature has absolutely condoned and affirmed this interpretation, because since 1991, both statutes of rape and forcible rape of a child have been amended. And no one, not one legislature amendment, has addressed or clarified force. That silence is telling. Force is encompassed by force of physical force and constructive force. And just taking a step back, it makes sense from a policy standpoint. Rape is a crime of violence that can be effectuated in many, many ways. And this case is an obvious example of how constructive force applies where a defendant, an adult, abuses his power as a caregiver and the trust of a vulnerable 12-year-old girl who didn't know what to do. She was terrified, she was scared, she had no idea what was going on. Your Honors, that is forcible rape. It is not statutory rape. And I would suggest that the defendant would even know in objective standing that at the time he was committing forcible rape. He crept into her room, he was making sure her sister, his wife, was sleeping, and then he continued to do this for 45 minutes. The defendant groomed this victim, and he waited to that moment where he could effectuate this rape. Your Honors, if there are no further questions or any questions at all, the Commonwealth will rest on its brief and the longstanding legal precedent that these convictions were valid and should be affirmed.
I see no questions. Thank you.
Thank you.
This matter is under advisement. Thank you both. Our next case is Commonwealth versus Rudy D. Ryan, docket number 23P893. Good morning, Attorney Chenna. How are you?
I'm well, thank you, Chief Justice Blake. Good morning, and may it please the court. Rachel Chana on behalf of the appellant Rudy Ryan. Both Kristen Kenny and Rudy Ryan each called 911. When the police arrived, someone needed to be blamed. Was it going to be Theodore Barboza, who was at the residence assisting Mr. Ryan's mother in kicking him out of his house? Or was it going to be Mr. Ryan, who was being kicked out of his house? The entire basis of the defense, as defense counsel explained to the trial judge, is that Kristen Kenny, Rebecca Barboza, and Donna Barboza had a motive to fabricate a story blaming Rudy Ryan to protect Theodore Barboza, who was serving a Superior Court probationary sentence due to end in only 5 days. With this court's permission, I'd like to focus this morning on my lead argument, the complete preclusion of Mr. Ryan's right to present a defense which is related to the right to cross-examine and confront the witnesses against him.
You're not saying that there was no opportunity, or are you saying that there was no opportunity to impeach on the basis of bias Theodore's sister, if you'll excuse my referring to her that way?
That's correct. This was not a complete preclusion of cross-examination altogether. However...
Not on the issue of bias. There was some questioning about her relationship to Theodore and bias on that basis. Is that right?
That's correct. Defense counsel was able to draw out some information regarding this family conflict and the family discord. However, the general tenor of bias and familial discord is markedly distinct from a material evidence forming a basis to fabricate a story. This was a very specific theory of the defense that defense counsel was entirely prevented from drawing out. And we know that Mr. Barboza, had this vulnerable status as a probationer, as Davis v. Alaska tells us. This is a very particular status of vulnerability that defense counsel was trying to draw out. And it's possible that the jury would think that defense counsel was merely seeking to impeach or the credibility of an otherwise blameless witness, when really what she was intending to do was draw out this material basis of a motive to fabricate.
But is the sister's knowledge of his probation status hearsay?
That's a really good question. I would say not. I would say that it would be a permissible basis for impeaching.
Because it's not offered for the truth?
That's correct, because it would be her motive
To fabricate.
right? And so this is her.
That's an exception.
Right, and Mr. Ryan's right to present a defense it would trump any hearsay.
As long as she
rule.
believes it to be so, that's what matters, right?
Exactly.
So when defense counsel asks the question to the sister, and there's an objection and the judge sustains it, seemingly contrary to what occurred before the trial began, do you think defense counsel at that time had any obligation to request a sidebar, to probe the issue further?
I think that the issue is sufficiently preserved for this court's review under a harmless beyond a reasonable doubt constitutional standard of review.
I think the judge was put on notice at the time that that was an improper ruling on the objection.
I believe that defense counsel sufficiently preserved the issue by raising the issue in limine, and when the judge in limine reserved ruling, defense counsel pressed the issue with the first witness. The judge prevented her from pursuing this theory of defense through cross-examination with the first witness. And so naturally, defense counsel did not attempt to pursue this theory of defense through cross-examination with the Commonwealth's second witness. And then at the close of the Commonwealth's case, defense counsel again raised the issue. I believe it's sufficiently preserved for this court's review.
Would this theory of bias apply to both witnesses or just the sister? That wasn't clear to me.
We don't know because because the trial judge prevented defense counsel from cross-examining the first witness on this basis. Naturally, defense counsel did not attempt to cross-examine the second witness.
Do you think there would
on
have
this
been a
basis.
plausible basis for asking the question to the second witness?
I think that the standard of review is clear that all ambiguities are resolved in favor of the defendant when we're examining whether this was harmless beyond a reasonable doubt.
What do you mean by ambiguities? I'm not understanding that.
So when this court looks at whether a violation of a defendant's rights were harmless beyond a reasonable doubt, all ambiguities are resolved in favor of the defendant.
What is the ambiguity that you're referring to?
Well, an ambiguity would be, for example, whether defense counsel thought she couldn't cross-examine the second witness on this basis because the judge had prevented her from cross-examining the first witness on this basis.
Oh, I guess
I
guess I'm asking different. So there has to be a plausible basis for the theory of bias, right?
Right.
I guess I'm asking whether you think that standard was met here as to the second witness, not anything to do with what trial counsel may or may not have decided to do based on the judge's first ruling.
Sure. The second witness, Kristen Kenny, testified that she was the best friend of Mr. Ryan's mother, that she was close not only with Mr. Ryan's mother, but with the entire Barboza family. She was in the upstairs level with Mr. Barboza on the lookout for Mr. Ryan. I think there's a basis that she was also close with Mr. Barboza and could have also known that he was serving a Superior Court probationary sentence due to end in 5 days, as defense counsel represented and sought to cross-examine about. In addition, when looking at the factors to determine whether this violation was harmless beyond a reasonable doubt, we look at the overall strength of the Commonwealth's case. This was not a case with overwhelming evidence against Mr. Ryan. We see that in the split verdict. The jury disbelieved enough of Ms. Kenny's testimony, disbelieved enough of the Commonwealth's case to render a split verdict.
How much of Ms. Kenny's testimony needed to be credited with respect, how relevant was the credibility assessment of Ms. Kenny's testimony to the malicious destruction of property charge? I'm not seeing that as a parallel to the charge on which they convicted. Meaning that it seems to me there are many other reasons why the jury could have found that the evidence didn't prove beyond a reasonable doubt the malicious destruction without any assessment of the credibility of Ms. Kenny's testimony.
They could have, but again, the standard is all ambiguities in this analysis are resolved in favor of the defendant. This was a pure credibility contest. On one hand, there was the testimony of Ms. Kenny and Ms. Barboza, and on the other hand, there was the testimony of the defendant, Mr. Ryan. There was no corroborating physical evidence. It was the word of these two witnesses against the word of the defendant, Mr. Ryan. The testimony of each of these witnesses was crucial to the Commonwealth's case, and Mr. Ryan was entirely prevented from presenting his defense on this specific point that was the basis of these witnesses' motive to fabricate a story to protect Mr. Barboza and falsely blame Mr. Ryan when the police arrived, which is markedly different from drawing out the general tenor of family discord.
Can I ask you about the limitation on the testimony about your client's back injury?
Yes, Your Honor.
So the briefs were helpful, but the transcript is sort of hard to follow. I feel like she excluded it, and then maybe it came in. Can you help me with that?
Thank you, Your Honor. I think this issue of the restriction on Mr. Ryan's direct testimony needs to be analyzed in concert with the restriction on his right to present a defense through cross-examination.
So you have to look at them together.
You have to look at them together in concert. And I believe Jacques, the case that I submitted a 16L about, is clear on this point about the need to analyze these 2 points in concert. What I believe the jury could have found through these restrictions on Mr. Ryan's direct testimony is that the judge repeatedly saying the jury is to strike from their memories any suggestion about injuries, and the inconsistency in her ruling for what testimony specifically was being stricken at what time, when he was testifying to substantially the same thing 3 times in a row.
Can I just ask this? Can you just, this is not a trick question, I'm asking, can you just remind me of whether those instructions were given contemporaneously with each of the attempts to introduce the evidence of the back injury?
Thank you. This would be on transcripts page 121 to 124. Contemporaneous to the objection and motion to strike in the first instance, the trial judge said the jury is to strike from their memories any suggestion about injuries. In the second instance, the trial judge said, in response to Mr. Ryan testifying that he had a broken vertebrae that were hurting him, that this response was stricken, and the response specifically regarding his back hurting prior to the altercation was to be stricken. In the third instance, the trial judge struck, they knew about that. You know, naturally, Mr. Ryan testifying to hearsay that his belief that his family knew about his broken L3 and L4 vertebrae was stricken rightfully. However, the ruling that the jury is not to consider that when viewed in light of her earlier instruction to the jury to not to strike from their memories any suggestion at all regarding back injuries, I believe was unclear and could have led the jury to believe that they were not allowed to consider the fact that Mr. Ryan had a broken L3 and L4 vertebrae at the time that this altercation happened, prior to the altercation.
So the judge, I'm looking at, it's strange to say this in a criminal case, sort of the equities.
I'm sorry, could you repeat that?
The equities, and what I mean by that is, I clearly, I understand your argument. On the sort of the other side of the scale, if you will, we have the fact that there was no prior notice of a potential self-defense defense, and the judge permitted that to go forward nonetheless. Does that at all, these are my words, nobody else's, sort of balance out what you say are the errors in this? So how do we weigh that?
Thank you, and I'd like to address that point about self-defense that Your Honor raises, because I believe it's a red herring, and I believe the judge's ruling on this point speaks to how chaotic this district court trial was, as many district court trials were, because the defendant had no obligation to alert the Commonwealth to his self-defense claim. Rule 14 is very clear about this. The previous Rule 11 required such notice to be given, but the 2004 amendments were exceedingly clear in removing that requirement. Mass Rules of Criminal Procedure Rule 14 specifically lists those defenses which a defendant is required to provide advance notice to the Commonwealth about, such as mental health, an adjutant defense. This was not an adjutant defense where the defendant sought to raise specific acts of violence by Theodore Barboza to imply that he was the first aggressor. This was not an adjutant defense, nor was this a mental health defense, nor was this a claim of license. Mr. Ryan had no obligation to provide advance notice to the Commonwealth of a claim to raise self-defense, which was his only defense.
Let me just check.
One quick question, Attorney Jonata. Back to the first issue, is the most factually analogous case Davis versus Alaska?
Davis v. Alaska is specifically on point with respect to the vulnerable status of a probationer. In Davis, of course, it was the witness himself who was the probationer.
Right. I'm just asking if there are any other cases factually that.
I would say Jacques is on point here.
Thank you.
You all said Shin. All set. All right, we will have to leave it there. Thank you very much.
Thank you very much.
Attorney Burbine.
May it please the Court, Carolyn Burbine for the Commonwealth. It's the Commonwealth's position that the defendant was not deprived of a fair trial where the judge exercised her broad discretion, which she limited the cross-examination of Donna Barboza. The right to cross-examine is not absolute, and as long as the trial judge didn't completely bar inquiry into bias, she had the right to limit the scope and extent here.
And is the judge permitted to completely prohibit one area of inquiry into bias, particularly something that seems like a fairly strong piece of evidence?
Well, it does, the court case law does say that a judge may properly foreclose such examination if the theory of bias is too remote or too speculative, and I would argue that this avenue of questioning was too tenuous. The limitation here, Donna would have had to know of the defendant's probationary status, that he was still under probation for the next 5 days. She would also have to know it was important for her to paint the defendant as the first aggressor in her testimony to protect him. She'd have to, paint the defendant as first aggressor to protect the victim, her brother Theodore, from heightened punishment in the event he was accused of a future crime because of his criminal record and his probationary status.
I don't know if she has to know all those things. So she's his sister. There's evidence they were close. Isn't it plausible that she would know about his criminal history and his probation status? Isn't that all that's really necessary?
I don't think so, Your Honor. I think that she would have to understand the need to say he started the fight, that he was the first aggressor, instead of just there was a fight and this is what happened.
Well, can I ask a different question then? If we're reviewing for abuse of discretion, it seems like the judge didn't make this ruling until after the fact.
She had said that she would hold off until the trial. She heard the defendant say she wanted to do it. She heard the Commonwealth's argument, and then she said, I'm going to defer until the evidence comes in and we start the trial.
The Commonwealth's argument, to me, presumes the question would have been fine, right? I mean, the prosecutor said something to the effect of, well, if the question's asked to a witness and it's established the witness knows about the probation status, that would be fine. And then when the question is asked, for whatever reason, the prosecutor then objects and the judge sustains it, and then later the judge, I guess, forgot that the question was asked.
She did later forget that the question was asked, but my memory of the initial conversation wasn't that the Commonwealth agreed that the question could be asked at all. I'd have to look back. I
It wasn't
apologize.
totally clear, but there were some statements about if one witness said she was aware he's on probation, then this would be appropriate.
Okay, I'm sorry, I don't recall that. But, as the evidence came in, of course, too, or as, I think we've all been in a situation where we've, said one thing and then thought about it later and thought, maybe I should object to that. That's actually, I was wrong before. So I don't think the prosecutor should necessarily be held to her initial.
Understood, but I'm just trying to ascertain what the basis for the judge's ruling was when the question was asked.
It seemed to, my impression from the record was that she felt it was too speculative, too tenuous. She said, I think this theory is a stretch, which I think goes toward her decision that it was too tenuous. And that, you know, I mean, for the reasons basically that I stated, although those aren't developed on the record, unfortunately. But, you know, it's our position that that this was not an error by the judge. And even if it were, you know, it was harmless beyond a reasonable doubt. And our position on that is that the defendant was able to testify in full about first aggressor. You know, it wasn't me, it was him, he grabbed me. And that where the defense was able to inquire into the broader topic of who initiated the fight through the defendant's testimony, the defendant wasn't prejudiced by that cross-examination not being allowed. So that is our position on that, that was harmless beyond a reasonable doubt. And also, I would note that the defendant didn't even try to question the family friend, who I would also argue it would probably be even more speculative with her, where it's not a family member, although she was a friend of the family. And I would also point out that there was considerable testimony about potential bias in favor of the victim from the two that testified. Donna testified she was at the house helping to pack up the defendant's belongings because Rebecca didn't want him to live there anymore. She was very close to her younger brother, Theodore. Ms. Kenny testified that she and Rebecca were best friends. She knew the family, including, you know, all of the siblings. And everyone testified that Donna and Mrs. Kenny had a strained relationship, that Rebecca had a strained relationship with her son. And then the defendant used that toxicity in closing to point out that Donna, Rebecca, and the victim were close. They didn't like the defendant. Rebecca wanted the defendant out of the house. Counsel argued that Ms. Kenny was Rebecca's best friend and she was not a fan of the defendant. She noted that they were all at the house when the defendant arrived and they blocked him from getting his belongings. So contrary to the defendant's claim, I assert that he was not deprived of the ability to show bias against him on the part of the witnesses that testified. Does the court have any further questions on issue 1?
I don't see any additional questions. Thank you very much.
Thank you.
The matter is under advisement. Excellent arguments. Thank you both very much.
Thank you.
Our next case is Commonwealth versus Scott T. Davis, docket 23P 1366. Good morning, Mr. Conley.
Good morning, Chief Justice. Good morning, Justice Shin and Justice Hand. May it please the Court, Alex Conley for Mr. Scott Davis. The principal issue in this case involves the practically how Gibo, the case from 2022, was, and I hope I'm pronouncing that right. I'm not sure if it's Gibo or Gebo or Gibo, but I think it's Gibo, how that's works in practice, really. The practical implications of Gibo in a case where a defendant on the date of trial requests a bench trial, and the interplay between the interpretation of Gibo and the rules of criminal procedure and the statute in play as well. A couple of key points from Gibo which I think control this case are the language used where it says that it would be absurd to allow unfettered discretion to deny a request for a bench trial on the day of just for only timing alone. It specifically says there must be other objective circumstances to allow the denial of the bench trial to make sense.
And there were some here, correct?
Well, I don't think that the judge made any findings of objective circumstances other than timing alone in this case.
What about the presence of jurors?
The presence of jurors, I don't see in the record why the presence of jurors goes against what the what Gibo requires as to why that would get in the way of the fair administration of justice just because jurors are present.
Is the appropriate husbandry of judicial resources and a function a part of the fair administration of justice?
Well, Your Honor, I think it could be, and I know what Your Honor's point is about how the juror system works and how jurors are given to courts and sometimes not if they're not used. It can be kind of an effect on my limited understanding is that the jurors, if not used by a court, can limit later jurors, perhaps. And that could potentially be something. I don't think that it's impossible that could be considered it. But what I think, especially with the interplay of Rule 19 comes into play, is that it has to be on the record. It has to be part of the finding. You can't just say that without saying it. It has to be, Rule 19 requires that good and sufficient reason for denial be given.
How explicit does that have to be? Is there a case that says how clearly in detail that explanation needs to be made?
I don't believe there is, Your Honor, and I think that's part of what Gibo kind of didn't explain. Gibo just said, here's Rule 19, here's what's required, here's some potential avenues that can be used, which notably they didn't use that as a potential avenue. The avenues they suggest as relevant are complex issues of credibility or the inkling of judge shopping. And notably in Gibo as well, the trial judge in Gibo kind of insinuated the same suggestion that there were jurors available, we brought jurors in Gibo. And that wasn't what the SJC suggested was part of the good reason that they found. The Gibo court in the SJC was very specific about the inkling of judge shopping and spent lots of time discussing why that was a good and sufficient reason, which of course...
So it wasn't necessary for them to address the juror issue?
I don't think so, and I think that...
So how much can we read into the fact that the judge mentioned that as well?
I think you can read into it that obviously it would be not any part of the holding that doesn't apply, but I think it's telling that they thought the inkling of judge shopping and spent paragraphs and paragraphs in the decision talking about why that's an issue, but didn't mention this thing. And also I think it's relevant, as I suggested to Judge Hand, that the judge would have and should have put something on the record if that's the reason. If the reason is we're concerned about our juror intake, that should have been on the record, not simply we have jurors, because that's vague. And it also would be unfair for litigants in certain courts. That's more of a practical argument. Certain courts, that's not a concern ever about jurors, because they have some of the bigger courts have superior courts and district courts altogether and have a giant pool of jurors no matter what.
And this was Air District, right?
This is Air District, smaller court.
Way out there.
Much smaller court, much less likely to have jurors, and I mean...
And the judge was specific about the the fact that there was a specific number of jurors who brought in. There were 16 jurors, if I'm remembering correctly.
Correct. I believe she said the number of jurors were brought in.
She said we have 16 jurors upstairs.
Correct. So I think it would be, then this is where Rule 19 comes in. I think that's why Rule 19 says specifically that it has to be on the record, it has to be good and sufficient reason given. I agree with the court that that hasn't been interpreted thus far as to how far that has to go. But I don't think it would be fair to say that anything can be interpreted, it doesn't have to say anything but I'm denying the bench trial, and we can look back after the fact and say, why was that? Let's look at all the circumstances from the past that could
But do you have to
potentially apply.
demonstrate prejudice?
So,
And if so, is the mere guilty verdict, and I don't mean that mere, it's obviously significant to your client, but is the guilty verdict enough to demonstrate prejudice?
so it's interesting as far as the prejudicial error standard applying to this case. I believe that's the proper standard. I actually went back and listened to the Gibo arguments again to see, and that was actually discussed quite a bit about what the standard would be, if it would be prejudicial error or not, or if it would require, there could never be an error that's prejudicial because of a guilty verdict. The appeals court decision in Gibo, which was overturned, they cite Commonwealth v. Pavo, which is a case where a colloquy was not given for a bench trial. And they say that this is closer in characterization to that, where there's no need to show specific prejudice because we can't really know how the litigants would have done in front of a judge versus a jury, what evidence would have come in, which evidence wouldn't have come in.
I mean, there's no constitutional right to a jury waive trial, so...
Correct, and that's why we are in...
Can't be structural error, right?
That's correct, Your Honor. It
So
can't
how
be.
do we assess prejudice then?
Well, and that's where it was interesting when I went back and listened to the Gibo argument. they had struggled with that. They said basically, how can there ever be prejudice in this case? How can we ever say that the juror didn't do as good of a job as the judge? And that's where this particular case was almost tailor-made for this thing. We have a juror who gave a comment after the fact and explained, at least from his or her perception, that the juror did not evaluate the evidence, the jury rushed to judgment, cherry picking is not a good standard. So that's where there is evidence actually of prejudice in this case from having a jury and not a judge.
Maybe, but wasn't the jury also polled, or not, it wasn't polled individually, but wasn't there a request for confirmation from the jury of the verdict that appears from the record to have been a yes from all of the jurors?
I don't recall specifically, Your Honor. I don't think legally it would make a difference, because even if a juror that comes out later, the case law would say that if a juror comes out later and says they didn't agree with the verdict, they can't overturn the verdict because of that. So whether or not they said at the time or not doesn't overturn the verdict. And I'm not saying that the verdict should be overturned because of this comment alone, but it's part of the analysis of prejudicial error here. And there's additional aspects as well for the prejudicial error here, given the other errors at trial. Specifically, we have the closing argument error, and I can go into that specifically as well.
Well, before you go on, so there's no constitutional right to jury waive. There's no statutory right to a jury waived, right? That's been held by the SJC. So without a right, what remedy is appropriate?
Well, I think there's a statute in place that allows which is
There is a
263
statute, but the
Section 6.
SJC has said that it merely prescribes procedures to be followed if the defendant wants to waive the jury, doesn't vest any right in the defendant. So without a right, how is there any remedy?
Well, Your Honor, if there was a right without a remedy, it would be superfluous. There'd be no point for them to have this procedures in place, to have the rules in place to allow it at all.
Well, it's because there's a right to a jury trial, so it's important to ensure that the procedures are followed when there's a waiver to that right. But if there's no separate right to a jury waived, it's hard to see how there could be a remedy.
I think the other point I'd make on that is that under Gibo, which in the SJC at least, they found that there was no abuse of discretion, and therefore they didn't fully analyze that. They do suggest that courts have responsibilities here. So if they have responsibilities, there has to be a remedy for them violating their responsibilities. I think it would just be illogical to say that the court cannot, it would be absurd to allow unfettered discretion to deny this, but if they do, it doesn't matter. That would create a further absurdity, I think. Again, then with the prejudice, both for this issue and as an issue in and of itself, we have things such as the closing argument here, which I'll skip to that one first, because I think that's an important argument as to why and how a judge would have seen it differently than a jury here. There was evidence, the self-defense was part of the argument in this case, and the Commonwealth's position was specifically at closing that the defendant threw his mother to the ground, and that said 3 times.
Why does that matter whether she was thrown? I understand your point, and I'm not disputing your point that that wasn't what the testimony was. But if the issue was the amount of force basically used, and the testimony, as I recall it, was that or could have been, the jury could have credited that the defendant put his hands on the mother's shoulder and threw her hard enough that she hit a cabinet corner and had to catch herself to avoid falling. Is that correct?
Well, that is correct. I think that is what the sister testified to, that version of events, and was slightly differentiated between the husband and the mother. In any event, I think that the way the Commonwealth argued in closing, being inaccurate, did go to the level of force used. It might still be a throw and a push, but when you have somebody thrown to the ground versus thrown into a cabinet or pushed into a cabinet, I think that does show a greater level of force.
But it doesn't matter, does it? I mean, the degree of force isn't significant to whether, if the jury credited the lesser degree, it would still be enough to convict the defendant on that.
Well, I think the jury would then have the option to say, was this a reasonable degree of force used in response to the touching that occurred upon him? So the reasonableness of the degree of force does matter. I think here, the evidence was from two witnesses that said that the mother put her hands on him first, and they characterized it differently. One says, I think one says grabbed his shoulders, one says put her hands on him. And if they believe that it's here, she put her hands on him, and he responded by throwing her to the ground, that's quite a different thing than shoving her back, or even throwing her to the side to a cabinet versus to the ground. So I think it is a pretty important aspect of the case.
And why didn't the judge's instructions that arguments are not a substitute for the evidence cure any prejudice?
So I think that this is the extent of the importance of that argument warranted a further jury instruction. There are cases that say that standard fair type instructions don't always ameliorate prejudice from improper argument, and I think this level of improper argument is what matters there. If it's something very minor, some like minimal fact that was misstated, a standard jury instruction that they're not evidence is appropriate. But here, where it went directly to the heart of the defense, directly to the heart of the case, I think that something more specific would have been helpful for the jury to really evaluate whether or not they would do that. And again,
And there was no objection, right?
there was no objection, so it's a substantial risk of a miscarriage of justice standard here. And again, for the prejudice, though, I still think for this as well, we can look to the juror's comment here, that they rushed to judgment, they didn't consider the evidence. And we can't know what evidence they did or didn't consider, or even if this juror felt differently than the other jurors who may have thought they did. But at least one juror thought they didn't consider the evidence. And if they didn't consider the evidence, I think there's a substantial risk that the evidence they didn't consider was the evidence of self-defense. They were taking upon themselves to say, well, here we have evidence, here we have an argument we just heard from the Commonwealth of this person who also, and I won't get into that issue based on my time, but making lewd comments toward her sister and throwing his mother to the ground. We're not going to consider whether he did that in self-defense. That would have been the evidence they didn't consider, the evidence they cherry-picked out, as the juror said. So I think even under the substantial risk of miscarriage of justice standard, that is some of the strongest evidence that there was some prejudice from this error. Briefly, as to the last issue I raised, which is the comments themselves, I do think that to a large extent, those comments overwhelmed the case. There was a significant amount of testimony from police officers, from the witnesses, from Danielle, the sister herself, about having had these lewd comments made to her. I don't see that they're relevant really to the case, and even if there is any minimal relevance to how the argument started, which I think is a bit far back from what the comments were, the judge should have taken it upon herself, and again, it's a substantial risk of a miscarriage standard here because it wasn't objected to at least make some kind of instruction. He's not on trial for making these comments. He's not on trial for making these, what witness Elaine testified to was not quite illegal but wrong. And again, given that evidence all came in, it was all heard by the jury, with the juror comment later made in mind, I think it shows a substantial risk of miscarriage of justice. If there are any further questions?
I don't see any. Thank you very much.
Thank you, Your Honors.
Attorney Langsam.
Good morning, Madam Chief Justice, members of the panel. May it please the Court, Jessica Langsam, Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth. It's the Commonwealth's position that there was no abuse of discretion in the judge's denial of the defense request for jury waiver. And looking at other language from Guibo than what my brother cites, the judge may deny such a request if there are objective circumstances apart from timing that suggest the defendant is or may be judge shopping. And I would suggest that in addition to potentially that there were 16 jurors or that it was a case that really involved making credibility determinations of a number of this witnesses in this intra-family dispute, that what the record shows is that there was judge shopping.
Does Guibo let us reach that conclusion even if the judge doesn't identify that as a potential basis?
I would argue that it does, Your Honor, because nowhere in Rule 19 does it say that, and I don't, it says, Rule 19 specifically says, and that's 19A, quote, "The judge may refuse to approve such a waiver for any good and sufficient reason, provided that such refusal is given in open court and on the record." And the judge did put the refusal in open court and on the record. And the record taken as a whole, reading that trial readiness conference where the judge said, quote, "I've seen Mr. Davis in various contexts. He reminded me at one point that he had seen me in Woburn. He's been through a lot, gone through a lot, has made an amazing recovery." And the judge also said, quote, "He's great, he is happy, and he is courteous. I just wonder whether pretrial probation resolution might be appropriate in this case." That's at the April 28th transcript at page 4.
And yet he still chose a jury.
I beg your pardon, Your Honor.
He still chose a jury after she made those statements, right?
The defense counsel still chose a jury, but 4 days later, when that same defense counsel is before the same judge, and as it's been referenced by the bench before, that Air District Court is a small court.
But that's not judge shopping, that's choosing between a judge or a jury. It's not judge shopping in the sense of Guibo, where there was a different judge who presided over the conference and then show up to trial, it's a different judge, and then suddenly the defendant decides to waive the jury.
Well, respectfully, Your Honor, I argue that it would still be judge shopping, where here defense counsel comes into court 4 days later, is not sure whether or not, in fact, there was another judge who was present for either the closings or the jury instructions, and the first Justice Maida said this other judge is here who's present. So there was another judge there, where defense counsel shows up in court and is before the same judge who had previously made these favorable comments, and then defense counsel says, okay, well, I want, or submits, and admittedly, the order in which this happened is not clear, that's not in the record. So where defense counsel submits his jury waiver form, and that this is the same judge who had previously made not only favorable comments about the defendant, but suggested a very favorable disposition for the defendant's case.
Shopping between which judges? I don't understand that argument, I really don't.
Well, in other words, Your Honor, the argument is that where this defense counsel sees, and I'm not sure if I can explain any differently, I just did, but where this defense attorney sees I'm in front of a judge who I know is, or who I can possibly infer, based on the comments that the judge made on the record before, is favorably disposed towards my client and who proposed a very favorable disposition, I want a trial just in front of that judge. I don't want to go to the jury. So in that sense, that's what I'm, so it's, in other words, so defense counsel makes determination not to gamble with the jury, but to go in front of this judge.
He's entitled to do that. I guess I'm seeing it more as an election between the judge and the jury versus shopping between two different judges, which is what happened in Guibo.
That's true. That is what happened in Guibo, and then the defendant, it was 12 days later, and defense counsel sees, okay, I'm in front of this judge, and then doesn't articulate the reasons under the form which the SJC indicated had been promulgated. And I would point to the court that that form was not completed, so we don't know. The record is sort of silent as to what the reasons were.
It wasn't the updated form, is that correct? The jury waiver form was
the jury, in fact, my brother and I discussed this before the argument, and that was not submitted. I'm not sure.
There's a date at the bottom of the
Which, there was a form, Your Honor,
waiver
that was
form.
submitted, that's part of my brother's record appendix, but the form that's discussed in Guibo, a specific 19A form, which is listed on the district court's website, was not submitted, which would have elaborated a little more as to why defense counsel was choosing, wanted to go for a trial before the judge. But
Do we know, I just don't remember, at the conference that took place the prior week, did the defendant know that Judge Mehta would be the trial judge the following week?
I don't know that that information is on the record, Your Honor. But I would also point out to the bench, and I know the court's familiar with the case law, that Guibo also recognizes that it's the trial judge who's in the best position to determine whether or not the defense attorney is judge shopping. And based on the record in this case, it's the Commonwealth's position that that was what the judge recognized, that even though the judge didn't articulate that at the time, that was still a good and sufficient reason under Rule 19A.
So in the perfect world, we would have a better record. We don't live in the perfect world. So can you just list for me, in a simple way, what findings you think the judge made that comply with Guibo?
The findings, well, the findings that the judge made went to, as was pointed out during my brother's argument by Justice Hand, that there were 16 jurors who were waiting. The judge pointed to the timing, which Gibo said, and so my apologies to Your Honor. So timing is not an issue. And those were the only reasons that the judge put on the record. I would suggest to the court
And then
that,
you're asking us to infer the judge shopping from the conversation that we just had.
well, yes, Your Honor. I mean, I would also suggest that having 16 jurors waiting does certainly go where Gibo talks about the fair and efficient administration of justice. That certainly goes. We've asked 16 citizens to set aside their day, come to court, and they were ready to come downstairs. And in fact, the judge is very solicitous throughout this very quick trial. We've got to get going. The jurors are waiting right outside. Let's get the train moving. But, and Your Honor, Chief Justice, I'm not so much asking the court to, infer that was sort of the story behind the story as to Justice Mehta's decision, because this is part of the record that the judge's opinion of the defendant as she articulated it, and her suggestion of pretrial probation. And then there was some conversation with defense counsel at the time, well, could it be a quaff? No, my client's not going to do a quaff. So where defense counsel shows up 4 days later, and this is fresh in his mind, and it's probably fresh in the judge's mind, and he elects a trial, and he wants to go jury waived, I would ask the court that for whatever reason, Justice Mehta did not put that on the record. As I said before, perhaps because Air District Court is a small court with the same, perhaps she didn't want to call out defense counsel in front of his client. We don't know the reason why, but the record is what it is.
But that's good trial strategy, right? I mean, that's what Gibo says. You make the decision because you think you're going to fare better before the judge than the jury. That's good strategy.
Well, it's, but for all of the reasons, Your Honor, Gibo discusses, it's not proper, and that's why the Chief Justice Ireland at the time had looked into the OUI, and the whole report was done, and then the working group formed after that. Because it's not proper for different dispositions to happen to individuals who are similarly situated. That's not justice. And so where defense counsel knows this, he can ask, and but the judge can also deny, recognizing what the story behind the story is, that's not fair and that's not permitted under the law.
Let's assume, just assuming there was error, how do we analyze prejudice, or is there any remedy at all?
I thought about that, and the standard is abuse of discretion, and LL versus Commonwealth explains what the abuse of discretion is. And that case says at 470 Mass 169 at page 185, we think it accurate to say that a judge's discretionary decision constitutes an abuse of discretion where we conclude the judge, quote, made a clear error of judgment in weighing the factors relevant to the decision. So
let's assume there was an abuse of discretion.
Assume there was an abuse of discretion.
Assume there was an abuse of discretion. How do we analyze prejudice, or is there a remedy at all in this situation?
I don't think there is not a prejudice analysis that follows, because it's an abuse. So if this court concludes that Justice Mehta abused her discretion in denying the defendant's request for a jury waiver, then the only remedy would be that almost sort of like a previous kind of redo of the trial under the former rules of the court, where you could elect another trial. So the defendant, the only remedy would be to have your bench trial.
So it's automatic reversal for a jury waive trial?
Well, in other words, it doesn't, if the standard is abuse of discretion, and LL versus Commonwealth explains how this court determines whether or not Justice Mehta abused her discretion, and I would submit to the court that there was no abuse of discretion here, because it cannot be said on this record that she made a clear error of judgment in weighing the pertinent factors, then there's no prejudice analysis is possible.
So then, to follow that to its logical conclusion, we could conclude that the judge abused her discretion, but there's no remedy.
And getting back to Your Honor, Justice Shin's point about, well, if there's no right or there's no remedy, I mean, where there's no constitutional right to the jury trial.
Right.
And there doesn't, then there is no other remedy. And maybe there is no remedy because at the end of the day, the defendant got what he was entitled to. He got a trial before a jury of his peers, or he got a trial, and whether it was before a judge or a jury, he got a trial that comported with the law. He wasn't deprived of any of his constitutional rights, and then, well, as for the arguments I made before, the judge, there was no error, or there was the judge's determination to not have a bench trial was not an unreasonable determination. I'm not so sure that I hope that sufficiently responded to your question, Madam Chief Justice.
It's tricky.
It is tricky, and I think perhaps trying to think through it shows that a prejudice analysis sort of doesn't apply in the situation, that it's simply rooted in an abuse of discretion, and then the analysis ends there. If I could touch on the other issues that my brother raises with respect to the closing argument, that the thrust really of the prosecutor's closing argument was that the defendant used more force than was reasonably necessary, and then based on the jury instructions, the jury concluded, as Commonwealth proved, that the defendant didn't lawfully act in self-defense in this case. I'd also point out to the court that the jury was properly instructed, that arguments of counsel didn't constitute evidence, that they were to follow their own memories of the testimony, and that they're presumed to follow the instructions. That was at trial transcript pages 39 and 137. With respect to the alleged bad acts, it was, no one viewed these as bad acts, not the parties, not the judge, and that's why there was no motion in limine, there were no limiting instructions, and rather what the comments that were made before that the defendant made to his stepsister were really part and parcel of this case, explained how the case arose, and even if they were somehow prior bad acts, the defendant wasn't prejudiced because they weren't improperly argued. They were never argued as propensity evidence. And they were never argued that the defendant acted in conformity. The prosecutor never argued, well, because he said these things, he must have committed an assault or an assault and battery. If there are no other questions, I would rest on my brief.
I don't see any. Thank you very much.
Thank you, Your Honor.
Let me just check with the panel. Could we do one more? Is that one more? Okay, we're going to do one more case and then take the morning recess. So the next case we will hear is Heidi Rose versus Tanya Santos, 24P250, Attorney Jean-Philippe. And as you come about, we want to apologize to you for the confusion around what was going to happen today with the motion to participate by Zoom. I take full responsibility. I misunderstood and read too quickly who it was that was requesting it, so I'm sorry if we unnecessarily called your office to change everything, but you're here, and we're glad you're here in person. So with that, please proceed.
Thank you. Not a problem at all. The clarification was great. Good morning, Your Honors. My name is Christelle Jean-Felix. I'm an associate at Casey Logic & Burns. I'm here on behalf of the appellant today. We are here to discuss the improper denial of the appellant's motion for reconsideration of the judgment and the underlying action, which, without any legal or factual grounds, improperly entered in favor of the appellee. There were irreconcilable differences between the facts of the case and the trial court decision that entered on December 21, 2023, denying appellant's motion.
The question I think I'm most interested in, I think I understand the issue with possession with Gomes and the money damages, but in order to award your client possession, which would ultimately trigger the sale, the judge would have to make a finding that there was rent owed. Is that right?
That's part of it, Your Honor, but...
Did he make that finding?
Did, Your Honor.
Tell me where.
So in the record appendix at page 21, the judge found that under page 22, Your Honor, that at the time of trial, the appellee owed at least 1 month of rent, and that at the time of trial, she had failed to pay $1,768.07 in taxes and $716.24 in insurance payment at that part of the record, Your Honor. And so specifically under General Laws, Chapter 279, Section 1, so what was required for the appellant to make its prima facie case for evidence was to show that the appellant was the owner of the premises, that an adequate notice to quit was delivered on the appellee, and that the appellee was holding without right. And that's exactly what the appellant met. Go ahead.
To quibble for a second, on page 90 of the record appendix, the finding that at the time of trial there was 1 month of rent unpaid, does that necessarily mean, where this trial took place the 30th of October, correct?
Yes.
And the rent that was in discussion was the October rent?
That's correct.
And there was no indication in the constructive trust of a date that that rent was due, was there?
That's correct, Your Honor.
So the unpaid does not necessarily, given that set of dates, mean overdue, does it?
So even assuming if that's, assuming arguing that that was the case, Your Honor, at the time we filed the motion to reconsider, Ms. Santos, Tanya Santos, the appellee, still owed 1 month of rent at the time.
But did the motion to reconsider, was asking to reconsider the original judgment,
the original
correct?
judgment, that's correct,
And
under a 59E motion, right? And so she still owed money. She still owes money currently, and I know that's not before the court today, but, you know, she has remained in arrears consistently.
Well, there's no evidence she owed money at the time of the reconsideration, right?
There is, Your Honor. It was...
I thought it was just representation of counsel, and she disputed that.
That's correct. My client did not testify that day.
So there's no evidence she owed money, right? So to Justice Hand's point, where the trust document doesn't say when the rent is owed, then why did the judge err in saying that?
So that's a fair point, and I would suggest that the fact that she had also failed unequivocally to pay taxes at the time, which were past due, and that she had failed to pay the insurance premium at the time, which were also past due, that she was in violation of the trust, the terms of the trust.
The judge found that was because they didn't forward her the invoices.
So
I thought that issue basically has gone away because you accept, I thought your brief was accepting the factual finding that she didn't pay taxes and insurance because she didn't get the invoices.
So we do not concede to that, Your Honor. She did receive the insurance payments, the tax bills directly. Only the insurance payment went to the appellant, and they tried to communicate, but it is on the record that the appellee had blocked her sister, and so the sister was not able to get in touch with her. And since then, the sister said, and she testified, that she had instead started to mail her documents using certified mail on a monthly basis to try to make sure that she got the notices. And despite her efforts, she continued to fail to pay, to the point that the appellant received a notice of cancellation for the insurance premium, at which point she paid it herself to make sure that the premium was not canceled. And she also paid the taxes because she did not want the taxes to remain in arrears. And that's exactly why the honor, upon hearing that testimony, allowed a motion to amend the summary process complaint, entering the money damages for the plaintiff, for the appellant, despite the fact that the appellant was not asking for money damages at the time.
And that would have to be a separate process, right? Could you do it under what you had filed?
You can ask for money damages. We weren't seeking those. The appellant was strictly seeking possession at the time. But my understanding is where the appellee had not filed an answer, any responses to the action, under Mass Rules of Civil Procedure 15A, the judge had the discretion to amend the complaint at the time for money damages. The issue...
Because he issued possession to the defendants, he couldn't award damages to the plaintiffs.
Absolutely. That's exactly what I was about to say. Thank you, Your Honor. And that is the very issue here, the crux of the case. The money judgment must follow possession and a summary process action. And the judge completely ignored that rule by splitting the judgment and giving possession to the defendants, the appellees, rather than the appellant.
I don't want you to go outside the record. I just want you to answer yes or no, because we can look it up on the docket. But have you filed a subsequent summary process action?
We have not, Your Honor. We're solely seeking the reversal of the order denying the motion and the amendment of the judgment such that possession would enter in favor of the appellant instead.
So if we affirm the judgment of possession, what are you asking us to do on damages?
So could you please repeat?
If we affirm the judgment of possession for the defendants, what are you asking us to do with the damages?
If you, unfortunately, if you affirm the judgment for the defendants, it would have to, the money judgment would have to be removed in favor of the plaintiff by law. By statute, the money cannot enter in favor of the plaintiff without judgment first entering in favor of the plaintiff. And I would also say, Your Honor, judgments do not enter in favor of tenants conditionally in summary process actions, right? That's not provided for under the general laws at all. And so the order from November 8, 2023 was completely improper by resetting the terms, as the judge coined it, between the parties based on some perceived authority, equitable authority to do so. The judge did not have the authority by law or at equity to enter the order that he did on November.
You haven't sought reformation of the trust in the probate and family court to provide for deadlines for payment, right?
No.
So I was a little puzzled by the notice to quit, which states as the basis that this is a tenancy at will.
Yes,
Could
Your
you
Honor.
explain that?
Yes, of course, I can explain that. So at the time that the notice to quit was being served, Ms. Santos, Holly Santos, had not made any payments under the trust terms. She had not complied. So essentially, by measure of caution, we chose to serve a notice to quit for tenancy at will.
I'm sorry, I didn't hear that.
For tenancy at will, right? Where if somebody has no right has ever been tendered and somebody is holding without right, they're entitled to 90 days notice. So we went with the additional.
But there's no claim in the notice to quit that she owed any rent.
That's correct, but if you look to the stipulations that are on the record, the parties did agree at the time of trial that there was a tenancy that was formed between the appellant and the appellee. And the rights of the appellant naturally flow at law to reclaim possession if the terms of the tenancy are not followed. And so based on the stipulations of the parties at trial, the parties did concede that there was such a tendency formed between the parties by behavior. And specifically on the record, it is recorded that on August 17, 2023, Ms. Santos made a large payment of $6,000, and again on September 1st of $500, which at the time acknowledged and created formally the tenancy. Does that satisfy? Does that answer your question, Your Honor? And I just want to touch upon with the time I have left for the issue of the apparent equitable order that the judge enters to allegedly reset the relationship of the parties under the Uniform Summary Process Rule 9. That's not appropriate. Equitable relief is only available in summary process cases by appointing a receiver or by issuing a restraining order or injunctions. And so the trial court had no equitable authority to enter judgment for possession in favor of the appellee. and when the appellant undoubtedly proved its right to possession. And I just want to come back to your question, Justice Shin, to the extent that we were relying on the determination of the tenancy at will under General Law, Chapter 239, Section 1. We still met the standard at law for the claim of possession, and under General Laws, Chapter 239, Section 3, the appellees only would have been able to receive judgment for possession of the premises after trial if the appellant was non-suit or if they failed to prove their right to possession. And in fact, the appellees did not raise any counterclaims or defenses to this action. And in fact, on the record, Ms. Holly Santos admitted that she owed 1 month's rent at the time and that she had not made the payments as she was supposed to, and instead stated at Record Appendix 1, page 91, that she was willing to pay the amount sought and obligated under the trust, right? And so whichever way you slice it, there was a tenancy formed. There were natural rights that flowed in favor of the appellant by virtue of that tenancy for possession of the premises, and the appellant unequivocally met the burden that it was required to meet at law to satisfy the prima facie case for possession of the premises. And I would also like to highlight a case that we cite in our brief, the Everett Housing Authority versus Pastios matter. And in that case, the judge did not disclose or discuss the legal reasons for allowing appellees right to possession. And just as the judge did not do so in that case, the trial court did not do so here. And in that case, they vacated the judgment for possession in favor of the tenants and remanded the case for trial so that they could rehear it and have the judge provide, make the proper findings as needed.
I'm very sympathetic to your client's position, but as a matter of law, if we read the terms of the trust, how can any judge ever find that rent is overdue?
Your Honor, respectfully, I do, the rent is due on the first, it's known, that's usually how tenancies work, right?
Do we have a case that says that?
It's usually by terms of it is usually by the terms of the parties, but
I've seen leases with the 15th of the month, 23rd of the month, we see crazy dates. And so I appreciate your argument, but I wonder if our hands are tied because of the terms of the trust.
Well,
not your fault.
Which I understand and I respect, but I also would remind Your Honor that she still owed the taxes and she still owed money on the insurance premiums. And so those were also terms of the trust, right? And the judge also found that she was allowing an unauthorized...
Those aren't defined in the trust, but those are due based on the invoice date?
Exactly, Your Honor. And they were absolutely past due at the time. And I would also add that the trial court found and recognized that she was allowing an unauthorized occupant to remain in the premises, which ended up getting rights that they were never entitled to based on the judge's order. The trial judge absolutely overreached and had no discretion whatsoever to enter and the order that provided for rights for a person that was never provided for under the trust. That is, the law also speaks to that, and I think that that's important for my client. And
you just check because your time has expired. Let me make sure there are no further questions, so we're going to have to leave it there.
That's okay. Thank you so much, Your Honor.
We're going to take about a 10 or 15-minute recess. When we return, we will start with United Financial Casualty versus Angela Bell. Brief recess.
Court is open. Please be seated.
Still good morning. Okay, our next case is United Financial Casualty versus Angela Bell and others, docket number 24P281. Good morning.
Morning, members of the court. My name is John DeSciullo, excuse me, and I represent UFCC. I may refer to it as Progressive during the
Could you
course.
turn the microphone? I'm having a little trouble hearing. Thank you.
How's that?
Much better.
So this is we consider it to be a relatively straightforward insurance coverage case. And specifically, the question at issue is whether one particular exclusion, exclusion 11, operates to eliminate the coverage for the claims that were brought by the Wilson family. You can find a copy of the policy in the appendix, and specifically the exclusion in question can be found at Record Appendix 459. And the exclusion reads, coverage under this part will not apply to an insured person for bodily injury or property damage arising out of the ownership, maintenance, or use of any vehicle owned by you or furnished or available for your regular use, other than a covered auto for which this coverage has been purchased. And the text that's in bold, those are all defined terms. One of the defined terms you'll see there is the word your. That's going to come up a little bit later in the argument. Now, in this particular instance, Angela Bell, who is a named party in the case, she's not here today, but Angela Bell was the UFCC policyholder. And we've produced a copy of her declarations page that can be found at RA 451.
Can I ask a question? Am I understanding correctly that sort of the heart of your argument, or at least one of the focal points of it, is that because you is defined in the policy to include the policy holder, named insured, plus a spouse at the time of the loss, that there is no ambiguity or risk of misunderstanding from a reasonable reader's perspective by the duty to update information about different changes in life, including marital status?
Yes, Your Honor, that is fundamentally the argument. And that's why I indicated at the outset, we consider it to be a fairly straightforward case. The definition of you that appears in this policy is similar to definitions of you that have appeared in other main policies that we've cited cases relating to in our brief. So, for example, we've cited Commercial Union versus Alves. That involved a homeowner's policy, and unfortunately a domestic abuse situation, husband against wife. The wife sued the husband, and the insurer relied on an exclusion for bodily injury to you. So in that case, the defined term you appeared within an exclusion. The court addressed the term and indicated that, and specifically referenced that the term you could include or be defined to include spouses residing in the same household at the time of the loss. And that court found that under the plain language of the policy, the exclusion applied. So we really see this as an analogous situation.
There was no issue in Alves about the timing of the marriage, right? They were already married at the inception of the policy.
Correct. It was a non-issue.
As a general principle, is coverage determined at the time of the loss?
Well, yes, it would be. Yes.
Is there a case that says that directly, that you're aware of, in Maine?
So I am, I'm not aware of the specific case, but conceptually, if you can imagine, if the conditions for coverage don't exist at the time of the loss, then there would be no coverage. If
So at the
premium
time
hasn't
of
been
the
paid.
loss here, would Helinski be covered as a relative under the policy?
She would be covered as a person meeting the definition of you, so a spouse living in the
But
same residence.
separately, would she be covered as a relative?
She would be.
If
But-
she, even though they didn't report the change?
Well, so there is no, although there is language in the policy that requires a policyholder to report changes, the definition of you operates separately from that.
Oh, I
claim.
understand. I'm asking, it's not directly related to this case. I'm asking, at the time of the accident, would Helinski be covered as a relative because the policy actually provides coverage for relatives, right? Insured person is defined to include you or a relative, and I'm just asking if an insured doesn't promptly report a change in marital status, would that come into play in determining whether there's coverage as a relative? Not the exclusion, the coverage.
So we have addressed that issue in our brief, and our position on that issue of a duty to report changes, that duty is one that is imposed upon the policyholder. It is not a duty that is imposed upon the insurance company. Now, certainly, if Progressive had, UFCC had wanted to rely on misrepresentation or failure to update the policy information, it could have pursued that route. But the insurance company is not obligated to pursue every possible defense, coverage defense that it has in a coverage case. What Progressive did was rely exclusively on exclusion 11, based on the fact that a spouse living in the same household as the policyholder does meet the definition of you, and clearly on the face of this exclusion, Ellen Helinski qualifies as a you. So once you go through the main case law, you see that the usage of a defined term, such as you, within an exclusion is permissible. That was the case in that commercial union versus ours. It happens in Massachusetts all the time. In fact, it's standard to use defined terms throughout a policy. You have language that is in bold. You can then go to the definition, and then you look at whether the definition is in any way ambiguous. In this case, the definition is found in paragraph 13 of the definitions. You and your mean the spouse of a named insured if residing in the same household at the time of the loss. So for whatever reason,
Is there anything in the language of the policy or in any decisional law about the timeline of which someone is required to notify the company of their marriage?
so
We read in something like a reasonable timeline?
if, I suppose that hypothetically, if Progressive was taking the position that the policyholder's failure to report a new household member, household spouse, was a basis for denying the claim, then you would ask that question. So that question becomes relevant once Progressive relies on
Failure.
that particular condition.
Okay.
But since we're not relying on that condition, we don't claim that
Doesn't matter.
she committed fraud.
That's why I was asking up front about the relative definition,
Right.
because let's say Helinski tried to claim coverage as a relative under the policy. Let's say the facts were different and she was driving and tried to claim coverage as a relative, but they didn't report that they had gotten married, then your client would have a defense that, well, they should have reported, because that might have resulted in an increase in premium, right? Because now you have an extra insured under the policy. But doesn't apply when you're talking about an exclusion, that concept. Because this exclusion's always been there.
Correct, correct, Your Honor. So, and this is a concept that we spoke briefly about with the lower court. By defining the term you and your in the way that UFCC did, it actually potentially expands the coverage, right? Because the grant of coverage applies to you, right? It applies to a you. So if the you is just Ms. Bell at the time of policy formation, she then gets married, and then there's an accident, and there's a spouse that wants to make a claim, the spouse is a you. So it has an expansionary effect. It also has, but it also expands the exclusion 11 parameters. So in other words, it works both ways. Now in this case, there is no factual dispute really on any of the main questions. We're all in agreement that Ms. Bell was driving her wife's vehicle, a Nissan Murano. That vehicle was insured by Liberty. No dispute that Bell and Helinski were married at the time of the accident, that they were living together. And there's no dispute that the Wilsons unfortunately sustained bodily injury and that those injuries arise out of the use of the vehicle. And so when you put all of those facts together and go back to the exclusion, we have a bodily injury arising out of the ownership, maintenance, or use of any vehicle owned by you. That would include Ellen Helinski. And then skipping forward, other than a covered auto for which this coverage has been purchased. Again, there's ample evidence in the record that the Helinski vehicle, which was being used at the time of the incident, was a Liberty Mutual Peerless insured vehicle. We produced testimony from Ms. Helinski to that effect. In our view, it's a straightforward application of exclusion 11 based on undisputed facts. So if there are no further questions, I'll rest on the brief.
I don't see any other questions. Thank you so much. Attorney Abraham.
Thank you. May it please the Court, Chief Justice Blake, Justice Hand, Justice Shin. My name is Andrew Abraham, and I represent the Wilsons. I'm going to disagree with my brother a lot, but I do think this is a fairly straightforward issue. And I think when you read Judge Deacon's decision, I think he's applying, one of the things that I think we all agree on is that we're applying Maine law here. I don't think it's probably substantively that much different than Massachusetts law when it comes to exclusions, but one of the things that Judge Deacon starts out with, and I think in his decision, which is obviously I think is correct, is that under Maine law, exclusions are disfavored heavily by Maine law, and that's in the Rideout case. They strongly disfavor exclusions in an insurance contract, and if there's any ambiguity with regard to that exclusion, then it's construed against the insurer. That's well-founded, well-cited Maine law, and that's what Justice Deakin found in his decision. I would point out that this is a case where, at the time, there is no fraud, there's no claim of fraud, there's no claim of negligence. Miss Bell truthfully filled out her application at that time. She was not married at that time. The application doesn't ask if she's engaged or going to get married. There's actually no evidence that they sent the policy to her, but that's a whole other issue, but let's assume that they did for purposes of this. because I think Judge Deacon did that in his decision. There is no fraud, and more importantly, there is no indication that the insurance premiums would have been risen had she listed or informed them that she had gotten married.
Isn't that reasonable to infer it would have gone up?
It is not, I don't think it is reasonable to infer.
Because at the time they get married, now Helinski's considered a relative, and she's covered under the policy. So don't they have to assess the risk of insuring her?
I would tell you that we had asked an interrogatory as to whether or not that would have raised and they didn't answer yes, put it that way. They didn't answer no, but they didn't answer yes.
What did they answer?
They said, we're not making this determination at this time because it's a hypothetical, essentially. But I would tell you, Judge, on this record, there is no evidence, and it was asked. It wasn't like, I'm not saying there's no evidence and no one asked, and the judge actually points that out in his decision.
Why does this matter? I'm having a lot of trouble with Judge Deacon's decision because I'm having trouble seeing how the failure to report the change matters. Because let's say they had reported the change. We'd have the same result, right?
No, actually, no. If she reported the change and listed her wife on the policy, then it would provide coverage. So that's the...
No, you'd have to have the Murano be a covered auto in order for there to be coverage. So let's say same facts. Murano is insured by a different company.
Yep.
They get married. They report the change promptly. The accident happens while she's driving the Murano. That's not covered. The exclusion would apply.
I believe it is because I think we will not cover anything used unless you are listed on the policy. If I believe if Ms. Helinski was listed on the policy, then it would be covered.
But the exclusion, I mean, correct me if I'm wrong, I'm trying to remember what the exclusion says. It excludes damage arising out of the use of a vehicle owned by you, which includes the spouse, other than a covered auto. So if the Murano's not covered, then how does the exclusion not apply?
Well, no, that's the point, is that the duty to report the changes, presumably she then would have the opportunity to list the Murano under the policy here.
All right, I'm assuming a world where all the facts are the same, and the only automobile covered by this policy is Bell's auto. So all the facts are the same, but they report the change in marriage status promptly.
Yep.
We'd have the same result.
But see, I think when you report the status change, you would get the Murano would have, at least she would have the opportunity to list the Murano under a covered auto.
But I mean, let's just assume she didn't. Then the reporting is inconsequential to whether the exclusion applies. If she had reported it and then tried to put the Murano as a covered auto under the policy, they would have to adjust the premium.
Maybe, maybe not. I don't know. But I will tell you, Your Honor, that's what, I mean, this case, and I think where Judge Deacon's decision is in the correct application of Maine law, is very, very similar to the Rideout case, the Patrons Mutual versus Rideout, and he relies heavily on that, Your Honor. And in that case, it is very, very similar. It was the husband and wife bought a family vehicle. They filled out an application truthfully at listing people that were living in their household at that time. Later, the daughter gets divorced, moves in, and the insurance company tried to cover it because under the plain language of the insurance policy, the daughter was not covered because she was not listed. And in that case, in the Rideout case, Your Honor, it talked about this. And it really, what it talked about was you don't want to have exclusions, Your Honor, that apply when it's very confusing to an average person whether they would know that the failure to report would somehow result in a denial of coverage.
So I see Rideout not as involving an exclusion, but sort of the opposite situation, where the plain terms of the policy would provide coverage, but the insurer was trying to rely on the failure to report as a reason to void coverage. And that makes sense to me in that context. But here, the exclusion has always said what it says. So this case, I think, would be different if the spouse was trying to claim coverage under this policy, but they failed to report the change in marital status promptly, and the insurer tried to say, well, she shouldn't be considered a relative or an insured for that reason. But the exclusion is always applied to the spouse.
But exclusions can, and I think under Rideout, there wasn't, the insurance company was operating, the failure to report also interplayed with the policy that excluded people that were regularly using the car that aren't being used on the insurance policy. So in every exclusion case, there's always an exclusion. So in Rideout, they were trying to exclude and also say that they failure to report the daughter because the policy required them, it excluded coverage for people that would regularly use the vehicle that were not reported in the household, or not reported on the policy, Your Honor. So I do think Rideout is on point. I think the larger ambiguity that he found was there was nothing to tell, or it was confusing it was confusing to an average person. And that's what the Judge Deacon found, that the failure to report the changes would result somehow, because that's it has to be understandable to an average person that if they don't report and don't list the Murano on the policy, that they're going to get excluded if they're just driving it once in a while. And that's what Judge Deacon found as a fact, and I think that fact is reasonable. When you look at the interplay of the policy, there's no way, it's just it's really a question of fundamental fairness. There's nothing to inform, or it's be very, very hard. It's going to say nothing, because if you're a lawyer, you probably can figure this out. But what the main law says, and frankly what mass law says, is that if it's difficult for an average layperson to figure out, unless they report that somehow they got married a couple of, I think it was 4 or 5 months after they filled out the application, that if they happen to be driving their wife's car for a single time or once in a while, that they wouldn't have coverage if they got into an accident, that's very hard to figure out. And that's why I think that's what Maine law requires, and that's why this exclusion should not apply. Because as Judge Deacon found, an ambiguity, and with the way the Maine law is that any ambiguity in the policy is construed against them, and it's really Progressive's job to make it clear to the policyholder that if you get married in the middle, you need to report it or you won't be covered if you drive your wife's car, and they didn't really make that clear. I mean, we can all sit here figuring it out as lawyers and as people that have read insurance policies, but what Maine law requires is that may be made clear to an average layperson, not to a law school educated person that has dealt with.
I guess it's hard for me to look at the language and say it's ambiguous. I mean, are you arguing the language is ambiguous, or that it's buried in there somehow so that a average person wouldn't understand?
Yeah, I think it's
Language itself is not ambiguous.
But it's the interplay of the and again, this is where I think Judge Deacon's decision is correct. If you look at the duty to report changes, it doesn't say that if you don't report that it's going to trigger a policy, you might exclude coverage. But in the same page, I think this is 49, in the same page, there's a fraud or misrepresentation where it says we won't provide coverage if you don't provide fraud or misrepresentation. So when you look at the policy in the whole, and that's what Rideout did. They looked at the application in combination with the policy and made a determination that was not clear to an average person.
But they had to do that in Rideout, though, because wasn't the insured relying on the failure to provide the updated information, which is something different than it seems to be the case here.
Yeah, but the insured was relying on the failure to update, and also the policy that excluded coverage for people that were using that aren't listed. And so they, again, in insurance, they're always relying on the policy. That's the only way that they can, there has to be some exclusion in the policy. So in Rideout, they were relying on it's a different exclusion than here. So that's our argument, is that Rideout's on point because it isn't clear. It is a question of, fundamentally, when you look at Maine law, and I think mass law is very the same, it is a question of fundamental fairness. Would an average person understand that the actions that they're going to take not result in insurance coverage? And I think when you look at the policy as a whole and look at the application, it is not clear to an average person. Judge Deacon found this, and I think this finding of fact really is certainly not abuse of discretion. I think it's certainly reasonable looking at the policy. It would be very, very difficult for a person to navigate this policy and make it clear to them that if they don't report report their wife, that they just got married, and that the wife has and enlist their car, that if they happen to be driving their car, that they're not going to be covered for it. We all can sit here now, but what Maine law says, and what they're talking, that's why you construing ambiguity against the insured, or the insurer, pardon me, is that unless that's clear to the policyholder, then the exclusion does not apply. I think
Okay,
that's
so let's say the insured, after purchasing the policy, buys a new car.
Yep.
And insures it with a different insurer. Surely an average person would understand that that car would not be covered under this policy, right?
I
Okay.
agree with that.
Let's say this exclusion said, instead of owned by you or your spouse. Would that be clear enough to an
I
average
think
person?
that what Judge Deacon said in his decision, I think he's right. They could do a lot of things to make this clearer, which is the other test that you could use. Could they have written this policy a little more clearer?
If the exclusion said it applies to damages arising out of the use of a vehicle owned by you or your spouse.
Yep.
And then now we have the same facts. Would the exclusion apply?
Yes, I think that would.
What you're calling ambiguous is the way that the fact that the exclusion only refers to you and the way that the you is defined elsewhere in the policy.
And the other thing that they could have done, I think there's two things that they could have done differently. They could have said you and your spouse, and even make it more clear, you and your spouse, even if you're married after this policy takes effect. But they also could put in the duty to report changes. If you don't, you may be losing coverage, which they don't do.
If it said owned by you or your spouse, how does a duty to report make any difference? I'm not understanding that.
Well, because I think when an average person looks at this and says, okay, it says due to report changes, and it says here that if I get married, it's a change that I got to report. What's going to happen to me if I don't? And again, I know we've had some disagreement, Justice Shin, about whether or not that at least would give her the opportunity to list the Murano under the coverage and get extra coverage. Because otherwise, if she drove her wife's car every once in a while, then she wouldn't have coverage if you interpret it the way they wanted to interpret it. So, but I think you're right. I think there's two different ambiguities. I think they should be writing you and your spouse to make it clear to the average person, and they should be telling them the duty to report changes. I think that's what Justice Deacon put in his decision. The duty to report changes is also tell them then at that point, if they don't report changes, they may be losing coverage. And so those are that's where the ambiguity is. And again, I will reiterate, given the standard, and I think it's a high bar for the insurer if there's any kind of ambiguity, if there's any way if there's any reasonable ambiguity here, Your Honor, I think it is to be construed against the insurance company. I think that's what the main law says. And again, I want to reiterate that ride-out, they focused on the application, but they did rely on the exclusion. And the ride-out court said that exclusion doesn't apply because they had no reason to know that they had to list that person on the application. And if there are other questions, I'll be happy to take them.
I do not see any. Thank you
Thank you.
both, gentlemen. The matter is under advisement. Our final case this morning is Cynthia McKenzie versus Ann Goger. I'm sorry if I've mispronounced that. Docket number 23P641. Before we start the time, Ms. McKenzie, I know that you are self-represented, and I think I've seen you in the courtroom a bit this morning, so hopefully you understand our process. But just to be clear, you are permitted 15 minutes of argument. Right in front of the microphone are 3 lights. The green light will go on when the argument starts. When there is a minute left, it will turn yellow, and then it will turn red, and that's when your argument will conclude. There is no rebuttal. After you complete your presentation, we will hear from Attorney Hoppel, and you cannot respond to anything she says, and similarly, she cannot respond to anything that you say. We may have questions for you, and we may interrupt you as we go along, and then you will not have an answer today. We take the cases under advisement, and you get a written decision in the mail and by email. So do you understand the process and the procedure of how we'll go forward this morning?
I do.
Wonderful. Okay, so when you are ready to begin your presentation, we will start the clock.
Cynthia McKenzie, pro se. I'm not sure what I can add to the argument I've already brought before you, other than utter fear of being here. The trial for my divorce started in 2019, April, and COVID hit, and I have to say that I'm sure the courts move more smoothly than they did at that time. That being said, I accepted the decision. It was an uncontested divorce and 50-50 custody of our child. And I accepted the decision and contacted my central pension fund for the division of the pension. And it was just an offhanded remark after I sent paperwork and stuff forward that the attorney for the pension said, wow, I can't believe you're being penalized for the allotted time, not back to your marriage. It went back to the beginning of time, the way the judge decided the division. And he said, this is a lot of money, you really need to consider it. And then I talked to a couple of other people and decided that, oh boy, I didn't realize that they had put it back to the beginning of time. And then I looked through the argument and the rationale, and I saw that Judge Peterson had attributed $109,595.71 of assets, calling them marital assets. The Central Pension Fund is funded by my employer. No marital assets were used for that. I tried to bring it back to the court then, and it couldn't happen because the period after the Nices thing happened, so I had to appeal. And the appeal process has been arduous at best for a novice. But in talking to Stanley Gross at the Central Pension Fund, he said, this is something you need to pursue, and so I agreed. That being said, I am doing it mostly for my daughter. In the 5 years since the divorce happened, my ex-spouse, Ann, hasn't been employed. Whatever happens to me, I'm 67 now, I am a blue-collar worker. I have not exactly been treated equally my whole life in a non-traditional female role, as you guys probably have a little reflection on that. But I have to do this to what is going to be the legacy that I leave for my daughter. So no money was used from the marital assets for the pension. So I think that's one of the biggest problems with this argument. Another is that we weren't married until 2004, but that marriage was only recognized in Massachusetts. My daughter was born in 2006. I would not be her mother in any other state. Under federal benefits that I didn't achieve any federal benefits tax-wise or income-wise. There's 1,049 federal benefits with marital status. I didn't get those. It wasn't until 2010, the United States versus Windsor, when Edie Windsor, who was with her partner since 1968, who unfortunately died in 2007, her inheritance that she was ordered to pay $363,000 to the federal government because it was not, her marriage was not recognized. It wasn't until 2010 that Edie Windsor won the case against the government, and that was the beginning of the striking down of DOMA, the Defense of Marriage Act. And I tried to explain this in the trial with Judge Peterson, but it is complicated, and I understand that if you're not in a same-sex relationship or have any involvement with people that are, and the complexities of that, it's difficult to understand, and I think that she didn't understand it. So it wasn't until 2015 that the actual Defense of Marriage Act struck down it wasn't until 2015 that the Defense of Marriage Act was actually struck down. And then we were able to get federal benefits. And it wasn't until 2022 that Joe Biden signed the Respect for Marriage Act, which insulated our protections under the law for all federal benefits, our marriage being recognized. Just an offset. Federal benefits are huge in a marriage. And I was actually penalized in the beginning of our relationship for domestic partnership benefits because I would have to pay the tax on the overall burden of what it would cost to have out-of-pocket insurance for my spouse, which was about $2,200 a year extra that a heterosexual couple with 10 kids would pay less than me with one spouse. A point of interest is Sally Ride went into the space for the United States, and her spouse was not able to get her Social Security benefits. I'm not arguing that Ann is entitled to some of my pension. That's not the argument. The argument is the period of time. I think it should be argued to the period of time when I was given the full rights under the law as a married couple. That's when it should happen. Other than being penalized, that is my argument. I don't know if you have any questions.
Do you dispute that your relationship began in 1992?
Yes.
What year do you say it began? What year do you say your relationship began?
We started dating in 1992. I'm not disputing that. We didn't live together for almost 4.5 years. When Ann first moved into my apartment, I had an apartment on my own. When she first moved in there, she left shortly after, actually, for about 3 months on a tour. Then she had a job when she came back at the little book room in Milton. And she worked for about 8 months and lost that job. And then she was rather distraught and upset, and she decided she wanted to go back to school. So we talked and talked and talked about that opportunity happening for her, and that I couldn't afford for her to go back to school, but I would provide the apartment if you went back to school, and you could work part-time and like buy groceries and stuff. But that being said, I've done that for family members too in my life. I just had, my friend just moved out. When I sold the house, she was living with me for 2.5 years. So Annie's niece lived with us for about 7 months when she left her husband. My brother lived with us for a little while. I mean, it's just the type of individual I am to begin with. I come from a family of 7 kids. Sorry.
Take a breath.
And any other questions?
Could I ask one about your pension? You say in your brief that your pension is federally funded. Is it funded by the federal government, or is it funded by your employer or some other way?
It's funded by an employer, but if you read the Central Pensions Fund main website, it will give you much more clarity than I could possibly.
And is that the basis for, is the website the basis for your statement that it's a federally funded pension?
No, well, I know that as a union employee. I mean, we talk about it often. We've talked about, privatizing our pension over the years, and it's much better in the place that it is. It's very well protected. And maybe federally funded is not the right word, federally protected.
You mentioned ERISA, so I understand your federally protected argument. I see that. Thank you.
I don't see any other questions from the panel at this time, and we have all of your papers, so you are free to use your time, or you can rest right now. It's completely up to you.
Well, good news. The kid just got accepted to both universities in Massachusetts, so.
Congratulations. Thank you so much. Attorney Hoppe, if I've said that right?
Yes, thank you, Your Honors. Good morning. May it please the Court, my name is Natalie Hoppe, and I represent the appellee Ann Goger in this matter. Your Honors, even if there exists, and I do want to acknowledge a lack of clarity between the findings and the testimonial values of the pension, I do want to let the Court know that it's our position that the pension should not be, the 40% allocation of the pension to appellee Goger should not be disturbed because it falls squarely within the including but not limited to language of Section 34 that precedes benefits, rights, and funds accrued during the marriage. Here, the lower court had the authority to divide the retirement assets accrued during the parties' premarital economic partnership. Your Honors, a division of marital property which is supported by findings as to the required factors, which we assert this particular set of findings should not be disturbed on appeal unless it's plainly wrong and excessive. Going back to the discrepancies between the testimonial value and the findings value, Your Honors, if I run the calculations through, the discrepancy is nominal. It would not be something that I would consider excessive, such that those values should not be disturbed. Your Honor, I'd like to touch a little bit on retroactivity. My understanding is that there has been a new decision by the Supreme Judicial Court, most recently discussing retroactivity of decisional laws. My brief did cover the retroactive nature of what I would assert would be the federal case law in terms of Goodridge relating backwards in time and Oberfeld relating backwards in times to the pension asset. The case that came down was Johnson v. Satino, and I believe it was in August of 2024. And it talks about retroactivity within the Commonwealth, which intersects, I believe, in terms of this being a federally funded pension. So I'd argue that our state's newer decisional authority in terms of retroactivity would also inform this court as to the extent that same-sex marriage was validated. That would somewhat of a domino effect push back in time as to the ability of the lower court and this court to affirm the division of the pension asset as it stands. Your Honors, these parties were in a long-term economic and relational partnership that started in 1992 and lasted for 12 years prior to their marriage in 2004. Even if the parties could not marry at that time, they moved in together in 1992. They affirmatively decided to cohabitate and apply their financial resources as well as their individual energies to and for the benefit of each other, resulting in an accumulation of assets, liabilities, health insurance, and the disputed pension benefits. Here, where the court found that the contributions made by appellant McKenzie to her Dana-Farber pension were diverted from the parties' expenses, it was equitable for the lower court to award the parties their respective shares as part of the divorce judgment.
Does it matter if, and I may be misunderstanding Ms. McKenzie's point of view, but if the argument is the amounts paid into the pension were not diverted from Ms. McKenzie's direct use, does that change your argument?
Your Honor, I would assert that even if it's not a direct use, it's the idea that the pension funds that were put in by appellant McKenzie did not benefit the parties together. So there was a reduction in financial assets that were available to them during their economic relational partnership. Does that answer Your Honor's question?
Maybe, but I think that I'm struggling a little bit with the reduction of the assets if the pension was being funded outside of the pre-tax dollars, so to speak, that were being earned. That's where I'm a little bit hung up on how that is removing or is reducing the amount that's due to the partnership.
So I believe, Your Honor, what I would be looking at is the idea that the money's being redirected. So in terms of the parties' current and ongoing financial, assets or income they were able to access while they were together, the pensions were being redirected, I think, with both parties' knowledge and consent into that pension during the time predating the time they were married. So where they had an economic relationship that was also relational, they had made a decision together that their available ongoing pre-tax monies was going to be reduced to the extent that Appellant McKenzie was then going to reduce the available day-to-day income or assets and contribute to that pension. So it did impact their time together before they ended up becoming married. That's what I would assert. Your Honors, I think if there's no further questions, I would rest on my brief if the court would.
I don't see any additional questions, so we will do that, and this case will be under advisement. I want to thank you both very, very much. That will conclude our sitting today of the Appeals Court. I would like to thank the court staff in particular, our court officers, our court law clerks, as well as our wonderful timekeeper. Thank you very much. We are in recess.
Did you understand that no money came from the paycheck ever?